hearing the appeal Ramsook against Crossley.
Yes, Mr. Hussain.
Good morning, please, my lords. Asaf Hussain, I appear on behalf of the appellant. My lords, with me this morning is Mr. Emil Pollard, Mr. Elvis O'Connor, and to my left is Mr. Derek Sylvester.
Big team.
Yes, please.
And Mr. Rowe has kindly agreed to act as amicus curiae. In the absence of the respondent, it's helpful to have someone present the arguments.
Well, I haven't regard to learned senior on the next side. His ability, I don't know if we have enough on this side, please.
Well, I don't think numbers are not necessarily the solution, but...
We've stopped deciding these matters by single combat.
at least that way, my lord, it would give us the appearance of having masses.
Yes, right. Well, let us proceed to the merits of the appeal.
Thank you, my lord. Lord, if I may just be permitted to just go through a brief history of this matter. We have filed full submissions in this matter, which we rely on, but I just wanted to highlight a few points, especially along the line of the cases that we have referred to. My lord, just before I start, I want to apologize firstly to the court that there is an error on the hard copy versus the electronic bundle that was filed. From pages 1 to 822, they both are in sync, but from page 823, we have a 2-page difference. So my humble apologies to that, but I will try as best when I'm referring to those pages to refer to both the hard copy as well as the electronic bundle, so that we...
Well, that's sensible because we are betwixt and between. Some of us use electronic, some hard copy. But right, now what were the points you wanted to highlight?
Yes. Lord, if I may go straight in there, because the facts of the matter have been set out before. There are 4 grounds which this court, honorable court, has granted leave on, please, my lord. The first 2 points, please, my lord, whether the insurers had authority under the policy to enter an appearance for the respondent, as well as the second ground, no jurisdiction to set aside a final order. My lord, those 2 really are points of law. So the cases, I think, guide us in the direction concerning that. My lord, if you look at the policy, the wording of the policy itself, and how one were to interpret such a policy, the wording of such a policy, I will refer, my lords, to the case of Lordgate Insurance Company Limited versus Citibank, and that is at page 930 of the e-bundle, and I believe at page 928 of the hard copy.
And do you have a tab number?
My lord,
because my authorities bundle is not paginated.
I think you've got, that's the old authorities bundle. There is a new one.
Yes.
Takes me to Beacon and Langdale. Is that where you were going?
What's it called again? 900.
That page number takes me to Beacon and Langdale.
I thought it was Ludgate and...
Well, it's the only authorities bundle that I've got.
Ludgate and Citibank is what you're looking at.
Yes, 928 in my...
yes. So,
right. Well, if there is another authority...
There's the electronic bundle.
Looks like that. No, I don't have it. I've only got the original one.
Which is Ludgate and Citibank we're looking at?
Ludgate versus Citibank.
I've got that at tab 3 of this bundle.
It's there, that one. Oh, right, okay, I have got it.
This one.
920, right? Yes.
No.
920, did you say?
928 on the hard copy, yes, please, my lord.
Right, well, that's Groom and Crocker in the volume.
No, I think it's 930 electronically.
930 electronically.
928.
Hard copy.
Hard copy.
Yes.
Well, it sounds like there's another authorities bundle knocking around, which I don't think I saw.
Yeah, I got it.
Either your lordship or my friends got got a spare copy.
Well,
it might be.
it depends what. It doesn't look like an authorities bundle because it's continuously numbered from 589, but it does have the authorities in it. Do you have that?
It may not matter because I've got located the old.
This one starts at 928.
Yes, I think.
I humbly apologize to my friend also. What had happened when they filed the original bundle with the court, because we discovered subsequent that the pages were missing, we informed our agents here, so they came back and refiled the bundle.
That's what's happened. Well, let's get on
Yes.
because you've given yourself a very short time and we want to get to the substance
Yes.
of the matter.
My Lord,
What's Ludgate help us about?
yes. My Lord, paragraph 35 of that judgment. Where it sets out, it says it is very well established that the circumstances in which a court will interfere with the exercise by a party to a contract of a contractual discretion given to it by another party are extremely limited.
We can accept that.
Yes.
The contractual discretion here is clause 15, is it?
Clause 15.
But the real question, I suppose, which is raised against you is, does it bite? And the courts below have said it doesn't bite because there wasn't, because of the judge's finding that there wasn't actual service, and they've treated it as a precondition to the operation of clause 15 that there should be service, at least when you're talking about a litigational situation. Do you want to address us on that?
And
I mean, we can all
Yes.
accept that there's a wide discretion, although for my part it must be subject to limits. Groom and Crocker demonstrates one of the limits.
Yes.
Insurers can't, I think, go around admitting liability when it is contrary to the known fact, and it may be that there are more limitations. In other words, they actually ought to consult with their insured, and it may be that Tattle, in this case, fell short, as I think you were suggesting to the Court of Appeal in submissions in the Court of Appeal. But that's a different matter.
so
So what's the authority for the proposition that Clause 15 bites on the judge's finding that there wasn't service?
well, my Lord, when you look at the authorities, and Beacon Insurance Company and Langdale is one, although there was service, there was not service, there was no litigation in that matter. These were all negotiations that took place prior, but they kept the insured informed at that stage.
Beacon is where then?
That is at page 951 of the e-bundle and at page 949 of the hard copy.
Right.
No, they had in that matter negotiated a settlement and informed the insured on it. But under that policy, he was liable for the first payment, or the first £5. They settled the matter at £45. And when they approached him for payment, he refused, and hence the reason why that matter was filed. And it was held in that case that the policy gave them the power to settle the claim.
They settled it with a denial of liability, but without consulting.
Yes.
Yeah.
Now, the other case, my Lord, is New India Assurance Company Limited versus Celine and others. That is contained at page 955 of the e-bundle, or at page 953 of the hard copy.
Right.
This was a case from the Kerala High Court, please, my Lord. And they use the term, that clause, a specific clause, which seems to be a clause that you find in many different jurisdictions as an excess or reservation clause or assignment clause. And they went into detail on that, the development of the law concerning that clause, please, my Lord. And at paragraph 21 of that judgment, which could be found at page 963 of the e-bundle, or page 961 of the hard copy.
Right.
If I may just quote, please, my Lord.
Yes?
It is therefore clear that the insurance company has a right to defend or take action against a third party in its own name on the basis of assignment. So here again, the principle.
Well, I mean, that can't be a correct analysis, can it? Clause 15. What is it assigning? You can't assign liability. It must be well, maybe it's this, in a loose sense, the assignment of the right to defend. But
That is so, my lord. That is precisely it.
Well, it's not, is it? It's simply an agency relationship.
exactly.
It is an agency relationship, but it gives the insurance company the discretion whether they wish to take over conduct of a matter.
Well, yes, but I mean, they've exercised that discretion.
Yes.
I mean, there are two quite separate points, aren't there? One is whether you can quarrel with their exercise of the discretion to assume the conduct of the proceedings, and the other is whether you can quarrel with their exercise of the discretion as to the way they conducted the proceedings thereafter. Now, the latter would probably not give rise to a right to treat the whole proceedings as void. The former, well, that's a question.
See, my lords, that is in where you have the agency agreement, servant and agent, master-servant relationship. But in this case, the distinguishing factor in this case, which is against that, is that here you have a representation clause allowing them to do what they did.
Yes, well, that's what you say. And you say, as Beacon shows, that they can do it even if there are no proceedings.
Yes.
Can they enter, when there are proceedings, can they enter an appearance through their solicitor in circumstances where their client has not been served with proceedings?
Well, my lord, I can speak from the practice in Trinidad. It happens on a regular basis where you find the enter appearance waiving service. And they put that on your called services waived.
Right. Well, I think in fact you get some comfort from the amicus's brief as well.
Yes. And I thank him for that.
But Mr. Rowe raises a further point, doesn't he? Namely, as to whether, in fact, there is a qualification on the rights that they must be exercised in good faith and within certain limitations, and otherwise are not validly exercised at all, to pick up Lord Sumption's point.
And my lord, we saying that the exercise that Tatil did at this stage, whether it was wrongful or not, really is not a question that has to be decided in these proceedings. That is, according to Groom and Crocker, where there is that problem or conflict, then the insurer has their right to go after the insured has the right to go after the insurer subsequent and get his remedy or her remedy as against the insurer for any breaches.
One of the problems in this case is that you don't appear to relied, or am I wrong, on Clause 15 before the judge.
Well, it was there, please, my lord. I understand my lord's point, but it was there. But what happened, and it seemed to be that there's a common error among some of the judicial officers, that they seem to misconstrue the law of subrogation as against the law of representation.
Well, I think your predecessor also used the term subrogation to describe what was happening, and it's clearly completely irrelevant in this context.
But Mr. Sanguinet, in his submission to the Court of Appeal, corrected that position. That's the reason why.
He did in his oral submissions, that's right, but in his written submissions, he wasn't so accurate.
Yeah.
Anyway, we understand the difference, and carry on.
So,
What is the significance of the fact that you just mentioned, namely that none of these points about whether Tatty acted wrongfully or not were really canvassed? The issue which seems to be in fought in first instance is whether there was service or not. But we're now discussing the case on a different basis, that irrespective of service, there's a right under Clause 15 to conduct proceedings, to which the answer, or possible answer put forward is, well, not if you're not doing so in your insured's interest.
well, my lord, and again, I apologize to say doing that, but we go back to Grumman-Proctor, which identifies remedy in that situation. If you are the insurer and you did not act in the bona fide interest of your insured, then the insured's remedy against you is, as identified by Shawcross, that you may sue for breach of contract or go to the court for declaration of your rights. So that in these circumstances, having regard to what Grumman-Proctor has set out, we're saying that is the remedy that
Yes, well,
Ms. Crossley.
We've got that point.
Yes.
And you say that that applies to the extent of allowing insurers to enter an appearance in proceedings which have not been served without consulting their insured.
That is so, my lord. And, my lord, if I may just refer to, and we have it on the e-bundle, King and Victoria Insurance Company, it is at page 971 of the e-bundle and 969 of the hard copy. My lord, while this was not on the point my lord said, but it also shows that there was no litigation, that there need not be litigation for the insurer to settle a matter. And this was a case where there was damage to the transportation of wool. And the insurer settled the claim directly with the bank, and the bank made an assignment to the insurer.
What is the title of this case? It doesn't seem...
King versus Victoria Insurance Company, please, my lord, 1896.
Yes,
Is that
nameless joy. Right.
And the page number, sorry?
It's at page 971 of the e-bundle and 969 of the hard copy.
Thank you.
So that is also another authority, albeit, because remember, my lords, the law in Trinidad as regards the insurance provisions have not really kept abreast with the pace as in the UK. So that these cases are relevant to the situation that we face in our jurisdiction.
What are we looking at in this authority?
Yes, the authority whereby the insurer could have settled a claim, and having so settled a claim, brought an action to recover the money that they would have paid.
Sorry, where's that said?
My lord, if I may turn to page 1 and page 2 give some facts of the case.
Sorry, page?
Page 1 and 2 of the judgment. It is page 972 of the e-bundle.
972.
970.
Thank you.
And page 970 of the hard copy.
I'm just looking for the passage which you want to draw our attention to.
My lord, the first 3 paragraphs really gets into the issue that was before the court. And if my lord look at the 3rd paragraph, the 3rd sentence, the other was to the effect that the plaintiffs had no right of action, or at any rate none in their own name, because the loss was not within the risk covered by the policy, and because the assignment of a mere right to recover damages were illegal. What had happened, my lord, when the bank had made a claim concerning the damages to the wool, the insurer went and paid the bank on their claim, and the bank signed off an assignment to the insurance so that they were not, but with the clause that they could not use the bank's name. So they brought the action in their own name. Having brought the action, one of the issues raised was that they could not have done so.
This is so far from this case. This is simply a goods insurance where the bank was the insured, and it recovered from its insurer, and later gave an assignment to its insurer. It doesn't really seem to me to bear on the conduct of third-party liability claims at all.
Indeed, but if I may just point, my lord, to page 974 of the e-bundle, or 976, sorry,
Right.
and page 974, the same judgment, the very first paragraph.
Yes.
It is true that subrogation by act of law would not give the insurer right to sue in a court of law in his own name, but that difficulty is got over by force of the express assignment of the bank's claim and of the Judicature Act, as the parties must have intended that it should be when they stipulated that nothing in assignment shall authorize it.
That's a case of a specific assignment
Yes.
of the cause of action by the bank to the insurer.
Yes.
I don't think we get any help from this case. It might be helpful just to look at the wording of the clause 15, might it, and just to have your submissions on
The page reference.
its breadth.
And my lord, clause 15, we can find it at page 767 of the bundle, please.
Sorry, page
767.
767.
767, yes.
It's separate, isn't it?
Yeah.
And the words, if I may be permitted, my lord,
Yes, we
page 767 of the bundle. It corresponds on both bundle and hard copy. No admission, offer, promise or payment shall be made by or on behalf of the insured without the written consent of the company, which shall be entitled, if it so desires, to take over and conduct in the insured's name the defense or settlement of any claim for indemnity or damages or otherwise, and shall have full discretion in the conduct of any proceedings. And my lord, if I may just pause there, it does not say that anywhere in this clause that there has to be an action, pre-existing action in court.
No.
And in the settlement, and this is important, and in the settlement of any claim, and the insured shall give all such information and assistance as the company may require. So this discretion that is given by this clause, my lord, is very broad and very wide. But with the riders in Groom and Crocker, that it must be done in the bona fide interest of the insured. So that if you did not take his interests into the consideration, then he has now a claim against you for any breaches under the policy. You may have a cause.
Well, did you make any reference at all to clause 15 in front of the judge? I'm just looking at your written submissions,
Yes.
which are at page 48. As far as I can see, they don't make any reference at all.
I mean, what one gathers from the judgment, where the judge helpfully sets out the issues that were before him, is that he thought he was concerned only with the question whether service had been effective.
That is so, my lord. Hence the reason why it was not delved into before.
And
His
didn't
Lordship.
consider the position on the footing that it hadn't been.
Pardon, please, my lord?
The judge does not seem to have considered what the position was on the footing that it had not been served on the defendant.
Yes, and my lord is right.
Except to say, in that situation, the proceedings have got to be set aside.
Yes.
So he doesn't seem to have considered that they
No,
might
please.
still be valid because of clause 15.
You know,
Well, whose fault's that? I mean, it's your client's fault, isn't it? If you look at your written submissions, you didn't raise the point that you engaged at page 48 purely and simply with the question whether there had been service or instructions. The ground being used in the application, that you said in paragraph 2, is primarily that the first defendant was never served, nor did she give Mr. Gozzi an instruction to enter an appearance or defend on her behalf, and then you engaged in the rules about service and engaged with that issue throughout the whole of the rest of your case. We can hardly blame the judge for not taking a point which you didn't raise, can we?
I understand my lord's point.
Well, how do we deal with it now?
The Court of Appeal, however,
But
that, as I understand it, was the sole issue in the Court of Appeal.
Yes, it was Groom Cocker.
yes, the Court of Appeal premised the...
You went to the Court of Appeal, and the issue was entirely whether Clause 15 gave the insurers authority to instruct the solicitors anyway.
And your case at page 48, it's an evidential rather than a legal submission, but you say in terms that she took the letter of before action to and left matters in their hands.
Yes.
Which is, of course, consistent with the Clause 15 arrangement.
Which is what we are saying,
Yes.
please. And when one looks at her, not only the pre-action letter, when one looks at under cross-examination also, please, my lord, when she was cross-examined, she again repeated that I left everything in the hands of Tattle, and that I was satisfied that Tattle was going to deal with the claim of Mr. Ramsook, and that is contained also at page 45 of the... So that not only in her affidavit did she say that in her evidence in chief, but also under cross-examination, she also reaffirmed that position.
Can I just go back to the point about what was argued in the Court of Appeal? Did you actually put before the Court of Appeal the insurance policy? I seem to recall that...
Yes, please, my lord, we did...
Well, where is that referred to in the argument? It's certainly not referred to in your submissions to the Court of Appeal.
Yes.
Your submissions to the Court of Appeal do what you did in front of the judge, as far as I can see.
Well, Clause 15 is set out at page 7 of the transcript.
Oh, that's helpful. Yes, that's right. He says,
and
slow down, he says, and he reads it.
And in his very brief judgment on the final page, he says the appeal has been, at least this morning, posited on the interpretation of Clause 15.
Yeah. So we eventually get there.
But, my lord, it also, as my lord rightly pointed out, but it also starts, if my lord look at page 4 of the transcript, which is contained at page 1111 of the bundle, you would see from page 4, my lord.
Yes, I see that.
They started looking at section 15, clause 15 of the policy.
Yeah, so he does argue the point. Yeah, and it becomes the point.
Because what had happened, the first panel that the matter came up before, it was raised with the first panel, and the first panel asked for both Mr. Rennie Gosign and Tattle be served with the proceedings. And on the return...
Ask them to do what?
To serve both of Mr. Rennie Gosign as well as Tattle with
Yes,
the proceedings, the appeal in the Court of Appeal. And that was done. And Mr. Gosign made an appearance through Mr. Roger Markey saying his attorney before the Court of Appeal.
Yes.
And you will see his name is mentioned in the transcript. But they did not think that Goodman Crocker, as they use, bite into this because of the non-service.
Yes. Well, as far as one can see, therefore, The point you are relying on now wasn't raised at all before the judge. It wasn't raised in your written submissions to the Court of Appeal, but it arose during the course of at least oral argument, possibly as a result of something that was said at the initial hearing. Anyway, wherever, it did arise there, and the Court of Appeal bowled it out. You now say it's a good point and is the answer to the whole case.
But also, my Lord, on the second limb, that whether the court had jurisdiction to set aside the policy, to set aside the order of the judge, please, my Lord. We have also referred to some authorities which we have put on our submissions, please, my Lord. And my Lord, and my Lord, if I may just take you quickly to page 1047 of the e-bundle, to the case of Santoshi Kojima versus HSBC Bank. Now, my Lord, that case mentioned a number of principles, and one of the principles is the public interest and finality of litigation. Now, my Lord, if I may just draw the
case went to the Court of Appeal.
but
Wouldn't be reversed.
Well, I think I was upheld, but for different reasons. I haven't been back and checked, but I have a nasty feeling in the back of my mind that that's what happened.
When was it? Yes.
Kojima. We can easily find it on Bailey, I expect.
2011.
there are a number of points in that case.
I think they thought
Yes.
that the judge may have made a better job of it than I did, but I may be misremembering entirely.
Well, I do apologize. We did not see the
What-
word
what- I mean,
authority.
What's the proposition you're looking for from this
Yes.
case?
Well, my Lord, that case did in fact mention about the English CPR 7.1, which allows for withdrawal of admissions.
Yes.
Yes.
But there's no local equivalent in our rules to that effect. When one examines our rules on admission, on liability, where you can admit a claim, my Lord, you cannot, as compared to the English rule, withdraw such an admission.
Yes, but that assumes there's been an admission. I mean, here,
Yes.
the case against you is it never got to the stage of an admission by the defendant.
Well, there was an admission, my Lord, by Mr. Gosain on the defense that was
I know,
filed.
If he had no authority, then it wasn't an admission by the right person.
I mean, supposing somebody brings proceedings against me and they serve them on my next-door neighbour, and judgment is entered against him, or he puts in an admission, it's all complete nullity, isn't it? And I must be able to apply to a first instance judge to have it set aside as a nullity.
Well, my Lord, in that situation where someone does that, there would be the instant issue of fraud that arises, so that
Well,
it could be...
Supposing he has an identical name and there's no fraud, but he just has nothing to do with me, and it doesn't matter fraud, does it?
It's difficult to see how he could honestly admit liability.
It's a nullity.
I understand, and Learned Senior on the other side referred to such a case, but the case Learned Senior referred to, that dealt with, say, for possession of property.
Yes.
But in this case, as compared to that, there is a material difference, because here it is, you have an authority, someone who you have authorized.
Well, you're getting back to Clause 15. It all
Yes,
turns on Clause 15.
it all turns on Clause 15.
If Clause 15 doesn't apply, in other words, if they were just completely acting without any authority, if it hadn't existed, Clause 15, then surely the insured would be able to apply to a first instance judge.
I agree with that fully, please, my Lord. So, and hence the reason why I wanted to posit the whole proceedings, and I agree with Learned Senior in his ultimate paragraph, that where, if it is that the court decides that Clause 15 applies, that brings the end to the appeal.
Right, so we can forget about that point as a separate point, really. It links into Clause 15.
It gets into Clause 15.
If it matters, my recollection was right, and it's reported at 2011 EWCA Civ 1709,
Yes.
which I think, taking it shortly, the Court of Appeal thought that the judge, the first instance judge, may have done a better job than I did on the first appeal. I don't think he actually disagreed with my analysis, but they thought the judge hit it spot on. Court of Appeal was,
Yeah, who's the first instance?
first instance Judge Mitchell in the Central London County Court.
Yes.
I'll be guided, my lord. But the principles, the analysis, the analysis, my lord, is what we were relying on in any event, so that the analysis that we have put forward by that case at that time, Lord, we say it's still sound analysis. But the conclusion may be different, but the analysis is sound analysis, please, my lord.
Tell me this, in the present case, your predecessor, in his submissions before the Court of Appeal, gave a pretty big hint or suggestion that the cause of action was against Tattle for, if anyone.
Yes.
But it was never taken up, presumably, the claim.
Well, my lord,
Or,
I understand pre-action letter has been sent out, but because of this appeal, they did not take the second step, which is to initiate any action. So pre-action protocol by Ms. Crossley was in fact sent out to Tattle as well as Mr. Gosai.
But they didn't sue.
No, because of this appeal.
But will there not be a limitation problem?
No, please, my lord.
No, won't she be time barred from pursuing Tattle now?
Well, no, my lord, because everything hinges from the order of the judge at first instance.
No, wait a minute. Her cause of action would be for wrongful conduct, you say, of
Yes.
the original litigation.
Yes. And
That's years ago.
until the court had decided that it ought to have set aside that it was a good order by the court.
Because her cause of action is for a breach of duty that happened and caused damage
Yeah.
at the time of the original proceedings. It's nothing to do with the validity of the current proceedings.
But anyway, it isn't directly your concern,
No, my lord. Not at this stage.
No, but it's
which is unfortunate, perhaps.
but right, all right. So what else do you want to help us on?
My lord, basically, it was just to go through the CPR, but my lords have all those, our local CPR before it in our submission, so that unless there's anything further to add.
Which provisions of the
It was just to go into this CPR Rule 14, please, my lord. And this is, again, on the issue of admissions. And if I may take, my lord, directly to CPR 14.3, we have, it is at page 1034 of the e-bundle, or 1032 of the hard copy.
Sorry, the e-bundle page?
1033.
1034.
I got it.
Oh, sorry, 34.
And it says, where party makes an admission under Rule 14.12, admission by notice and writing, any other party may apply for judgment on the admission. Now, my lord, in this case, again, there was no application before the court, but through the urgings of the court, as well as the parties and the defendant at that time, an order was in fact made. So an order of the court was made pursuant to the admission in the defense that was filed. And sub-rule 2, please, my lord, the terms of the judgment shall be such as it appears to the court that the applicant is entitled to on the admission.
Well, this is all standard.
Yes. And the reason why...
We're really dealing with the prior stage of whether there's authority to make an admission.
Yes, grateful, my lord. So that in these circumstances, please, my lord, if I may just, we have agreed more or less that clause 15 is where everything turns on. So,
Yes.
What about Mr. Rowe's point, which is based on one sentence in my judgment in GAN, typing and GAN? You've seen that case, have you?
Yes, we have referred to the case, please.
He suggests that where he suggests, with reference to my analysis of Groom and Crocker, that where an insurer's solicitors go further than they should have done,
Kindly ask.
that's not a question between the insured and the insurer. It could go to the insured solicitor's authority, and it could undermine the validity of what is done.
I think, my Lord, you had made that reference as regards whether the same clause would be applicable in reinsurance.
Yes.
Yes. So, my Lord, again, it's the same, it come back to the same Groom and Crocker position. So if it is that there was that breach by the insured or the reinsurer in that situation, then one may have claim against the other for breach, because it's the same sort of authority that is being given.
We've got to be clear, haven't we, about what breach or arguable breach we're talking about. It's one thing to say they had no authority to make the admission because it wasn't in the client's interest.
Right.
It's another thing to say they had no authority even to set the proceeding or to take over the proceedings. It's only in the latter case that the proceedings themselves are a nullity. If they're a nullity, it doesn't matter who had authority to do what afterwards. It's all got to be washed away. So what one's got to focus on is, was there authority to conduct the proceedings at all, not whether they did something which they shouldn't have done in the course of conducting them.
And we are saying,
I wonder whether it's as simple as that, because unless they were held out as having authority to act in the proceedings, it might be that they had actual authority to enter an appearance, but not actual authority to make an admission. And so the proceedings might, I suppose, on that analysis, at a certain stage become invalid.
and my Lord,
As far as the admission is concerned.
and my Lord,
Relying the appeal on the substance, it can't possibly be a reason for upholding, setting aside the judgment as having been a nullity, which is what's actually happened.
if I may answer both my Lords.
Yes.
First, when one looks at the wording of the clause 15, it gives a very wide discretion. So it talks not only about proceedings, but also of settlement.
Yes.
So that, in answer to my Lord's question, and where my Lord was drawing the distinction, we say even that situation, because of this wide discretion, and they enter the appearance.
But that depends on the facts, doesn't it?
Yes.
I mean, if they studied the facts and said, well, this looks a pretty hopeless case on liability, we might as well admit it, that'd be one thing. If they said, well, we know that she wasn't at fault, but frankly it's too much trouble, we'll admit liability, that might be another. So, one's looking at a totally different factual investigation.
And the facts that reveal itself in this matter is that she got a pre-action letter. She took it in to the insurance according to her version, and they told her that they will see about it. And she, in her under cross-examination, she said, I left everything in the hands of Tattle. So that the factual situation does not show that she was she was unaware of the proceedings.
Well, this was about 6 months before the supposed service.
That is so.
Somewhere in April 2000.
Yes.
Yeah, or May. Yeah.
Yes, your position is she gave all the necessary authority, and if the insurers, having that authority, failed to take account of her interests as they should have, that doesn't go to their authority. It may go to their liability for breach of contract.
That is so, my Lord.
That's your
Yes.
case.
And my Lord, to answer my Lord's question, when one looks at the board's decision in Nandram versus Ramsaran, which,
What?
just permit me 1 second to find the page. That is at page 985 of the e-bundle, or at page 983 of the hard copy. This was a case that involved property dispute, my Lord.
I'm sorry, I think I misheard the page now.
985 of the
985,
e-bundle,
thank you.
yes. Or page 983 of the hard
Yep.
copy. It is Limondal Nandram, I hope I'm pronouncing it correct, my lords, versus Lumas Ramsara, 2015 board's judgment. Now, my lord, that case also talked about ostensible authority. And at paragraph 9 of that judgment, my lord,
Yes.
it says parties to, I'm just paraphrasing, parties to civil litigation are masters of their case. And this was a case where there was a property dispute, there was a settlement, the appellant in that matter was before the court, and he consented, or he confirmed the settlement to the learned judge. Subsequent to that, he went to other attorneys and then brings a complaint that the settlement was done without his consent. So that the authority by the board on that is that counsel, even without actual authority, counsel.
But that's counsel who are instructed. It begs the question. If or as the judges found, there were no service and she gave no authority, then all you've got is clause 15, so you're back to actual authority, aren't you? And then you have to consider that, as my lord said, firstly at the stage of entry of appearance, which on the face of it was entirely pro forma because it was with reservation of liability without admission. And then perhaps there's a second stage where the admission was made.
The further point to that, my lord, is that the opposing litigant, the third party in this case, and pursuant to the board's decision in Nandram, please, my lord, the third party ought not be concerned with the relationship between the attorney and its client, my lord,
Yeah,
on the opposing side.
I can see that.
Yes.
Again, it slightly begs the question. I mean, if all you're relying on is clause 15, we're concerned with an actual authority situation, not an ostensible.
I'm guided, my lord.
Not a holding out.
Yes.
Can I just ask one thing? Are we going to say anything more about the facts? Because part of your appeal is
Yes.
on fact. What do you want us to do about that?
Yes. If I may just...
I don't want to cut you short.
No, not at all, my lord. Yes. On the facts, please, my lord. If when one looks at the transcript of the Court of Appeal, page 1108, and I think both bundles should correspond to that.
Yes.
Right. And they looked at the balance of prejudice at page 1110, when Mr. Sanguinan...
What's the start of that page?
Let's permit me one second. 11.
What are the first words on it? Because I've got a... I don't think I've got 1110.
What's at the top
Supplement.
of the page, what is the
First word.
page number?
I see. Page,
I don't have an
we
MS.
come at page 3, please, my lord.
It's page,
That is page
Page.
what electronically?
1110.
1110. Thank you.
So you're looking at page 3
Yeah.
from the manuscript.
I think so.
Okay, right.
Yes.
So what are we looking at?
And this was Chief Justice of Appeal Smith, please, my lord. This is the 9th line, where he says, and that was because we had asked you to engage, that your only hope was if your policy, what your policy said. We had indicated and you said you had more or less agreed with that. It depends on what the policy said. So this goes back to the...
Yes, I see. It goes back to the clause
Yes.
15 points, yes.
Yes.
Oh,
So-
Justice of Appeal Smith was the one who was there on the previous
The
occasion.
first panel, yes.
I see.
Now, when one looks at line 30, that same page, please, my lord, lines 38
Okay.
to 45, right? And this is where it is. Where the prejudice lies. Is it more against the claimant or against the first defendant? And my simple answer...
Page, you were?
This same page 3, please, my lord.
Line
Line 38,
38.
yes.
Right.
This would be 1110 of the bundle. Where the prejudice lies, this is Mr. Sanguinetti. Is it more against the claimant or against the first defendant? And my simple answer to that, my lord, it must be with all respect the greater prejudice must be against the claimant because the defendant has recourses open to her to deal with the attorney, to deal with Tatil, or alternatively, both Tatil and attorney can explain.
Fine, yes,
Yes, and he goes on, but that is an issue between them, not to affect the claimant.
yes. But
No.
you made that point.
Yes. And the very next page, please, my lord, line 7 to 22.
Yes.
Again, Mr. Sanguinet, if you look at page 14, my lord, and you see under section 15, representation, and the English Authority of Groom and Crocker bears it out, and then Chief Justice of Appeal, Mr. Sanguinet, you must admit there's a difference between this and Groom and Crocker immediately.
Well, this gets back to clause 15.
That's
again.
clause.
Yes, clause 15 again.
Yes, right.
And then they went on to,
Could you just
No,
tell
page-
me what? Yes, carry on. Yes.
yes, page 1114, my lord.
Yes.
And this is where we get into about the service. And it starts at the top, my lord.
Right.
Mr. Sanguinet, my lord, that is the right of the insurer. And if the insured is not served, they could accept service on behalf of the insured. So
Yes.
he has alluded to the fact that the insurer can, in fact, accept service on behalf of the insured. And
Right.
if the case necessitated, waive such service. Now, my lord, if I may just turn quickly to the decision of Justice Devines.
Can I just ask you one thing about the Court of Appeal?
Yes.
Do they set a time limit for hearings?
No, my lord.
Because I mean, I only ask because the hearing appears to have taken a very short time. I don't know.
Because this was a procedural appeal, please, my lord.
I see.
So it was filed as a procedural appeal.
So there are lots of cases listed on that day.
Yes, procedural appeal usually comes up within a month or two thereafter.
And it's conducted more by way of conversation than by way of submissions. But perhaps that's also a criticism that might sometimes be made in this court.
Well, my lord, they do file submissions. They do file
Yes,
submissions.
oh no, we've
Yes.
read the submissions.
Yes.
So I have.
So-
But no, I just wanted to know. I mean, as a matter of interest rather than anything else, normally one would expect to see developed oral submissions, but the written submissions take the place of those.
Well, my lord, what we
They
find...
don't seem to have covered the subject which
Yes.
was dealt with in oral argument.
The Court of Appeal actually, they deal with some very interesting points of law, but they do not usually, presently, you do not usually, except in very rare cases that would reduce it in writing, you now have to go into the transcript and search. But the problem we face with that is that when you take some of those transcripts to the judge of the first instance, as it happened to me, the judge would indicate, well, that is just banter between the bench and bar. Where is the authority that they have said?
So that's what you get now because of this is essentially a
Yes.
procedural appeal. It's probably different with a substantive appeal.
Well,
Anyway, where were you going next?
Yes.
But am I right that the clause 15 point and Groom and Crocker came up for the first time at the first hearing?
yes.
This is covered by paragraph 33 of the Statement of Facts,
Yes.
and that says it was brought up by,
Mr. Sanguinet.
yes, Mr. Sanguinet, but not by the court.
No. And after that, the reason why the court adjourned the matter and asked that both Tatil
Yes.
and Mr. Gosain be present on the next occasion, which we tried to do.
Which paragraph did you refer to?
33 of the Statement of Facts.
Are there two statements of facts?
Yes, the first one, unfortunately, my lord, I think
Yes,
that is where the error...
I've been looking at the wrong one there.
Well, yes.
Where do we find the correct one is a supplemental bundle, is it? Yes,
Yes.
probably. Right, 33.
So it came up before the Court of Appeal for the first time. That's the agreed statement.
And it was raised before the panel that heard this matter and eventually gave decision whether the matter was part heard. And
Yes, I see.
the Chief Justice indicated he did not believe so, so hence the reason why they proceeded with the appeal.
Yeah, well, that's very helpful. Where were you going next?
Yes, on the issue of service, my lord, and the learned judge dealt with it at page 16 of the bundle, please, my lord. It's under analysis 16, or is it, I believe it may be 18, I do apologize. Under analysis of issues, was the first defendant served with a claim form and statement of case? Or it's 18, my lords.
Which paragraph?
My lord, it is paragraph 25.
Yeah.
And my lord, we say his lordship made heavy weather of the defendant, or in this case the respondent, not signing the documents upon receipt. But the rules, my lord, our CPR rules provide for handing it or leaving it with the person, and not necessarily that they have to sign for receiving it. So that's one distinction we wanted to draw to the court, because his lordship said, well, Mr. Hardat could have gotten, or he did not produce any signed document.
Well, he made that point both about Mr. Harnath and Miss Bailey.
Miss Bailey.
But I mean, the question which the judge didn't answer is the question which Mr. Sanguinet put in the Court of Appeal.
Yes.
Do documents, writs, fall from heaven?
Yes, and that is so, my lord. Because you see, my lord, what transpired subsequent to that, 12th of November 2010, an appearance was entered. So the first time an affidavit was filed as regards a service in this matter was almost 4 years after that fact. So that when an appearance is entered and a defense subsequently filed, there's no need for an affidavit of service, save and except if you're going for default judgment. You need to prove that there was service. But where you have an appearance that was entered, there's no need by the claimant now, at that stage, to file any affidavit of service. So that the first time that comes before the court is 4 years after the fact. And we're saying that that timeline, and the judge did indicate that he understands that Ms. Bailey is given evidence 4 years after the fact. But the same leeway we say is not given to the Mr. Hardat evidence that is put now before the court for the very first time. And another thing I wanted to draw to my lord's attention, Ms. Crossley has put forward as an exhibit CSC 8, I believe. That is the card of Mr. Hardat.
Where is it, actually? Can you just identify it?
It's 287, I think, in record volume 1. That's Mr. Hardat's business card, is that right?
Yes, please, my lord. My lord, I have it at page 295.
295.
295. 287 may have been the original file document.
Well,
Page 295.
doesn't matter, as long as you can find it.
Yes. And, my lord, when one looks at the date, because in her evidence before the court, when Mr. Hardat came on affidavit to answer Ms. Crossley's affidavit on her application, he had indicated the handwriting on the back of that card, which is produced as the annexure. That wasn't his. And Ms. Crossley came back and filed a supplemental affidavit indicating that that handwriting was made by her. That handwriting is hers, and was made on the day of the service, well, not the service, when Mr. Hardat visited. But, my lord, when one looks at Friday the 4th, my lord, there's no Friday the 4th, and this was in August. I think she was referring to the month of August. It was really a Thursday, and even the Saturday the 5th was really a Friday. So if it is assuming that she was correct, even at that time, and this would have been a contemporaneous note of Mr. Hardat's visit, and there was that error. Similarly, we say that come 4 years later in her affidavit and her cross-examination, she could have made the same errors as regards her being served with the document. Further to that, my lord, she has indicated that she was out of the country on the 12th of November 2010. And we have no argument with that because she has produced her passport. But on the 8th of November and the 9th of November, when Ms. Bailey says that she visited her at Tattle's office on the 8th and she faxed the document to Mr. Gosain on the 9th, two issues arise here. One, is it not more plausible to believe that I am someone who is now being faced with litigation and court proceedings. I am leaving the country in a few days. Let me quickly go down, because I believe she left the country on the 10th of November. Let me quickly go down to my insurers who already told me that they will see about it and give them these documents, which she did on the 8th. And we're saying that she did she was served on the 8th. She went down to Tattle's office on the 8th. And on the 9th, and then we have corresponding with that, which we say the judge, having had the advantage of seeing the witnesses, he did not take proper regard for. We have the evidence of Mr. Gosain, who has also indicated that and produced to the court a fax from Tattle's office of the 9th of November 2010, showing that the document was in fact faxed to his office on that day. And Ms. Bailey...
Are we talking November?
My apologies.
Yes, it's November.
Yes, 9th of November.
It's November, isn't it? Yes, I thought we said August a moment ago. November, right. Yep.
So here you have that which runs in line with what Ms. Bailey said.
Can we just look at that document, the 9th of November one?
I don't believe we have the actual fact sheet attached to the bundle, please, my lord. But it is on his lordship's finding. And if you look at page 22 of the bundle.
Could you give me the paragraph number?
I believe it starts at page 23, paragraph 38, my lord. My apologies, my lord. It starts at 36. Under cross-examination by attorney for the first defendant, Ms. Bailey responded as follows. And then I received documents from Ms. Crossley. I did not know her before. Page 23, my lord, paragraph 36.
Yeah.
It goes on, I did not receive identification from her. When I received documents, I checked that we have insured with that information. I did not ask her for identification. I had never seen her before. There was no endorsement on document. I kept the original and referred it to attorney. I did not make record. To my memory, it was after 3 p.m. that I received documents. I did not make note of time or date. I prepared fact sheet, which was sent directly to Mr. Gosain. I faxed it the following morning. So this was on the 8th, and she's saying I faxed it the following morning, which is consistent with Mr. Gosain's evidence that he received a fax on the 9th.
Yeah.
9th of November.
Yeah. One of the things which, I'm just going back, one of the things which the judge held against Mr. Hardath was that he didn't produce the notes from his notepad
Yes.
with the driver's permit number or refer to such details in his affidavit.
That is so.
His affidavit, he did produce them in oral evidence, didn't he?
Yes. My lord, his affidavit, I believe, is at page 223.
Yes. Well, his affidavit says he's making this from records and
yes.
recollection, so he referred to records. But he did produce the notes, if one looks at page 43, in his evidence. Do we have them? I don't think we do have them.
Don't believe the notes were produced, please, my lord, because in answer to the judge, he did...
He says, I have my notes here, the entry for the 8th of November, and he reads it out.
Oh, I see. But I'm not sure if it was tendered, my lord, because we don't have it on the bundle.
I see, but he wasn't cross-examined on that. Nobody said these are forged or you...
No, please, my lord.
They're not made up on the date when...
And that is one of the points we also made, that there was no allegation of fraud or collusion between Mr. Hardat, or in this case, the Ramsook and the insured Tattle.
Yeah. Right.
And another point, my lord, is the issue of the use of the term evening.
Oh, yes,
yes.
We've got that point, yes.
Yes.
Well, I mean, it does sound slightly strange. Why shouldn't the judge be right on that? It's a bit odd to describe anything from 1 o'clock onwards as evening, isn't it?
Well, my lord, it may sound strange to my lords, because, my lords, in your society, that is a normal, a proper way in which you do things. But in Trinidad society, my lord, unfortunately, through time, the fluctuation of time, my lord, those beautiful ways that we inherited from you all have slowly gone by the wayside.
But what,
The judge must be,
yes, why isn't the,
familiar with that.
why,
But
why isn't
he
the
is.
judge a better place?
But you see, my lord, because that judge and a lot of the judges, they come from proper backgrounds. in the sense that they were trained in the Sunday schools and those sort of things concerning the proper usage of
Take
those.
judicial notice of this sort of material.
But, my lord, and I would gladly invite my lord to Trinidad to
Can I think take judicial notice of when the sun goes down and the shades start to lengthen in Trinidad, which is fairly much at the same time throughout the year.
But he's an
If it happens
indigenous
quite early in
judge.
the afternoon in
We
December.
might at least, I suppose, I see he's Mr. Justice A. Devine, so he has what sounds like a French name.
Yeah, hence the reason why he
But
comes
he's
from that lineage.
indigenous. He's an indigenous Trinidadian.
Yes, but those persons, unlike myself and many of us here, we cannot trace our heritage. But those persons, because they have that lineage, you can trace. They can trace it all the way back into France and England and those sort of things. But unfortunately, the rest of us, our records were lost on the ship or wherever it was lost, or change of names or whatever. So, my lord, and the reason why I pointed that, my lord, the reason given by the judge for disbelieving Mr. Harrat on the point of usage of the word evening and what he termed to be afternoon evening is he said that Mr. Harrat used it to bring it in line with Miss Bailey's evidence. Yes. Now, two things arise from that. One, is it again how we come into collusion or fraud between Miss Bailey and Mr. Harrat? That was not an issue before the court, before the judge. And secondly, Mr. Harrat is given this evidence and Miss Bailey is given evidence in the absence of each other because it was a contentious proceedings. So Miss Bailey goes first, she gives her evidence. Mr. Harrat goes, he gives his evidence, and neither one is within the court to hear the other given evidence. So that conclusion drawn by the learned judge, we say, having regard to the observance of the witnesses, he did not take proper advantage of.
Well, anyway, Miss Bailey simply said that it was sometime after 3 o'clock. It may have
Yes.
been quite late in the evening.
But what could be alluded from what his lordship was saying is that Mr. Harrat came to give evidence to coincide with what Miss Bailey was saying. But there's nothing before the judge to indicate that there would have been some sort of collusion or conversation between both to know what time frame they were each going to speak about. Unless I can be of any other assistance.
No.
I thank you for the opportunity, please.
Thank you very much indeed. Mr. Pollard, do you wish to add anything?
Nothing further to add, my lord.
Thank you very much. Yes, Mr. Rowe, can you help us on points?
Well, I'll try to. It's certainly true that at the trial there was a focus on the question of service rather than on the question of Clause 15 and the effect that it might or might not have.
Yes.
I think it's fair to point out there is at least a brief reference to authority in the judgment of the judge towards the end. I may not be able to give your lordship's page references because it sounds as if what I've got is rather different to what the board has, but it's my page 24, it's page 21 of 23 in the judgment, if your lordships have that.
Paragraph?
It's Little Roman 7, my lord, inside. I have to go back because it's a long series of Little Romans, para 55.
Yeah.
Yeah. Good.
Since Rule 40.3 is inapplicable to the facts of this case, I think the judge is really talking at this point about the question of jurisdiction to do what he's about to do. But he goes on to say it was not necessary for the first defendant to show by evidence that it's likely that if she had attended, some other judgment or order might have been made. The first defendant was not personally served, and the judgment entered against her on the 16th of May 2011 was based on the fact that Mr. Gossin, by entering an appearance and filing the defence admitting liability, warranted that he had her authority to do so. Since he did not have any such authority, the first defendant is entitled to move the court to set aside the judgment based on that irregularity. So he does at least expressly deal with the suggestion that Mr. Gossin had authority to
Yes, well, I mean,
do that.
he wasn't assisted by reference to any possible source of authority.
No, that's right. And then what seems to happen, as your lordships have seen from the Court of Appeal transcript, at least of the second Court of Appeal hearing, the answer seems to come back, well, yes, he did have authority because of Clause 15. And the Court of Appeal didn't think that was a good point and dealt with it, albeit very cursorily, on its merits by saying that we didn't get there because there hadn't been service.
Yeah.
So, I mean, it's not a matter for someone in my position to make concessions on behalf of the respondent, but it may be that if the board thought that the Clause 15 point was a good one, then it wouldn't be improper to rule upon it, notwithstanding that it wasn't raised at first instance.
Well, it's
the Court of Appeal.
Ask. I mean, it's difficult to suggest that it's not before us properly before us when the Court of Appeal admitted it.
Yes. I mean, I suppose forgive me, I'm sorry.
Apparently without objection from
Yes.
Mr. Ryan.
Yes.
Yeah.
Yeah. So, I mean, I suppose one might have said, well, as a respondent's notice point, well, this wasn't taken at first instance, so
Right.
it's too bad. But then that might have been the answer. Well, it wasn't.
Well, it wasn't taken in the notice of appeal. It wasn't taken in the notice of appeal or the submissions, but it crept in.
It did emerge.
Yeah.
The Court of Appeal said that Clause 15 can't apply to a case where there's not been service. And again, it's not for me to concede anything about whether they were right about that, but one can see that there's an objection to that, which is that plainly, in a case where there's no question about authority of whoever it is who enters the appearance to enter the appearance, then once the appearance is entered, the question of the service being valid or otherwise becomes a matter of history.
Well, you put this very clearly, haven't you, in your note? And
It's the.
I mean, it is we're told it happens all the time, but we don't, of course, know that. But it sounds strange if it wasn't something that happened from time to time with consent. I suppose the question is whether Clause 15 allows it to be done without consent.
Yes. Certainly with consent, one can see how it might be done, because whoever was representing, with actual authority representing a defendant, might say, well, okay, there's a point about service, but if we take that point, they'll just reserve, or if we're within limitation, what's the point? Let's just get on with it and deal with it.
Well, they might well say, look, you don't want to be put to the trouble of having this served on you. Why don't we get them to send it to us and we'll deal with it on your behalf? Yeah. I'm sure that happens.
It might do, yes.
But what happened here is a bit unusual, certainly as regards subsequent events.
Yes.
No discussion at all about with the insured at all.
Well, quite. I mean, on the judge's findings, there was the defendant was actually completely unaware of the existence of the proceedings. Yeah. So in those circumstances, it does seem very odd that the insurers should have decided to acknowledge service, because if they were interested in if they were thinking of their own interests and hers, then even at that stage, one would expect them to say, well, let's take a point about the absence of good service. I mean, generally speaking, insurers are not in the business of making life easier for claimants who are claiming damages for personal injuries.
Well, except that, I mean, if they're going to end up paying the costs, it makes no sense for either the insured or the insurer to play around on service and simply say you must reserve a second time. I mean, what would be the point of doing that from anybody's point of view?
Well, one can see that. There are no doubt arguments either way as to what would have been the right thing to do, bearing in mind the interests of insured and insurer. The real question, you know, may think, is whether, in fact, the acknowledgement of service and the subsequent admission of liability were done with authority or not.
Let me take those in stages.
Yes.
If there was an acknowledgement of service done by the attorney on the basis that the attorney had been, that the insurers had Clause 15 authority to instruct lawyers to deal with the claim, did the attorney thereafter have ostensible authority to admit liability? In other words, is it really an actual authority at both stages or just the first stage?
Well, my Lord, one can see why it might be said that once the lawyer is on board, he has ostensible authority.
How can he? Because that's bootstrapping, isn't it? Well, I mean, you're not entitled. You mean the mere fact that he's acting?
Well, I think the premise of Lord Briggs's question was that he had actual authority at the point that he enters an appearance.
Well, yes, if a lawyer effectively goes on the record
Yes, I see. Yeah.
by entering an appearance, I'm looking at the document, it's at page 679 to 681 electronic. If the lawyer goes on the record by entering an appearance, and if there was actual authority under Clause 16 for the insurers to get lawyers on the record to deal with the claim, then my question is, why doesn't the ordinary ostensible authority of a lawyer, which extends to settling the case or admitting liability, then cover anything that happens thereafter?
On the facts of this case, the answer might be because of Mr. Gossine's letter, to which I make reference in the note, which actually makes it clear that he's not acting on behalf of the insured at all.
Well,
my Lord, in my papers, that's at 144. I don't know where it is in your Lordships.
Well, he's acting on behalf of the insurers. The whole assumption of that statement is that the insurers are conducting the proceedings on behalf of the insured.
And
that would be the ordinary assumption, Lord, I accept, but if one looks at what he actually said, that assumption is pretty firmly dispelled in my submission.
but he certainly says that in the entry of appearance.
Well,
What was the page reference you referred to?
My reference is 144. I've only got what appears to be an earlier iteration of the case papers.
Yes, that's right. It's the handwritten writing. It's 152 in our bundle.
152.
The hard copy.
This is the letter of the 12th of January 2011. I act for the first defendant's insurer in this matter, who admits liability for the collision. So right at the outset, that's a little bit odd, because ordinarily solicitors, even if they may be appointed by the insurers, are acting for the defendant. The limit on liability is referring to the policy, although in fact he's wrong about that, because the limit on liability is 1.5 million, but 1 million is the amount for which the insurer can go down under the direct right of action, or the right of action parasitic on a judgment, under the Trinidad equivalent of what in England is the Road Traffic Act.
I noticed that. Presumably it's not within your knowledge. It may be within the knowledge of the appellants whether or not the further £500,000 has been claimed.
As I understand it, the only way in which it could be claimed, under the terms of the Trinidad statute, which, as I say, is equivalent to I should have said England and Wales and Scotland, in fact, because it's the same act for both jurisdictions, forgive me. But under that act, the vulnerability of an insurer, as it were, to a claim by a claimant is limited to the extent of the compulsory insurance, which is $1 million. On the other hand, it seems in this case that the insurance was actually for 1.5 million. And as I understand it, what gave rise to this litigation, this part of the litigation in the first place, was a bankruptcy petition that was brought against the defendant. And as I understand it, what could happen is that there's an equivalent in the motor vehicle legislation, albeit it's more narrowly tailored because it only applies to motor vehicle cases, of the Third Parties Rights Against Insurers Act. So once you put the defendant into bankruptcy, you can then take over her right as against the insurers to be indemnified in respect of not the whole of the claim, of course, because the policy only covers up to 1.5 million, but the next $500,000.
Yeah.
As I understand it, that's what's behind all this. But of course, that will still leave her vulnerable to the balance of the claim.
Yes.
So she'll in practice be made bankrupt and have no assets. But, my Lord, I was looking at Mr. Gossine's letter, which is a pretty remarkable document in my submission, because it doesn't say that he's acting, as I say, on behalf of the defendant, but on behalf of the insurer. And then says the limit on liability is 1 million. My client is willing to pay this sum, my client being the insurance company, it's pretty clear, in full and final settlement of its liability for its insured. You are free to pursue any sum in excess of 1 million against the defendant, its insured, and or the second defendant, who was the Attorney General. And then he says he's going to refer the letter to the attention of the court. So it's actually...
But presumably Mr. Gossine took part in the subsequent proceedings, all of which took place on the assumption that liability was not an issue, as between his client, the defendant, and the claimant.
As a result of... as a result of his putting in the admission of liability in the defence.
I think that the substance of your point might be that this shouldn't have been treated as an admission of liability, but the proceedings thereafter continued on the basis that there had been an admission of liability, as I understand it,
Well, the reason the proceedings continued on the basis of an admission of liability was because a defence was filed by Mr. Gossin, purportedly on behalf of the defendant, by which he had her admitting liability.
So why wasn't that within his ostensible authority as the defendant's attorney?
Because ostensible authority requires there to be some representation by the ostensible principal.
Well, it requires there to be some representation by the ostensible principal or somebody with authority in that behalf, on behalf of the ostensible principal. So if you confer actual authority to represent you on a solicitor, for example, and he instructs a barrister, and an admission is made, what has happened is that with actual authority, the barrister has been clothed with ostensible authority to say whatever he subsequently says in the course of proceedings.
Yes.
There may be a breach of duty, and some of the things he might say to the client, but that's another matter.
Yes.
I mean, you don't disagree with that.
Well, I can't quarrel with that analysis, my Lord. The question is, how does it apply to the present case, where you have this very clear indication by the lawyer, Mr. Gossin, that he is in fact acting solely in the interests of the insurance company, and indeed positively invites the claimants to go and chase after the insured, who is on the face of that letter a stranger,
But he
for
then,
the balance which is not covered by the policy.
because I understand he then he signs off a defence admitting liability for the defendant. Do you have a page number for that?
I agree with that, yes. The defence, in my numbering...
It's 273, isn't it?
300, I've got 350, I'm afraid. But,
Oh, yeah.
I mean, this letter is an attempt.
Yes.
I mean, although it's obviously written under the shadow of litigation, it's an attempt to settle a potential claim. And because the insurer isn't on the hook, except in relation to a judgment, which hasn't happened yet, it's not a very sensible letter to have written, because there's no liability direct of the insurer which is capable of being settled. But what he seems to have been trying to do is to settle a prospective liability of the insurer, something which would necessarily operate, although he may not have appreciated this, as a settlement pro tanto at least, on behalf of the defendant. But does it matter? Because it's all water under the bridge. It didn't lead to a settlement, and he subsequently entered appearance on behalf of the defendant.
well, yes, in fact, actually, your Lordship says subsequently. I think.
No, he'd done it already.
It's actually just before. I think it's...
He'd done it on the 3rd of January,
He'd done it on the...
admitting liability.
The 4th of... Yes, I think for the purpose of this argument, one would... what I would say is if you regard it as part of a continuous transaction, effectively... on the 4th of January, is my note, there may be the 3rd, he files the defence, purportedly, on behalf of the respondent accepting liability, and follows it up almost immediately with this letter.
Yeah.
And the question is, in those circumstances, well, I suppose there are two questions. First of all, does he have actual authority to admit liability? My submission is no, he doesn't have actual authority, because it's quite clear that he is acting on behalf of insurers who are not considering the interests of the insured at all. That's my...
the mere fact that he says, I'm acting for the insurers, I mean, they have the conduct of the matter. The inference is that they have the conduct of the matter, and the inference is that he will have taken account of their interests properly. I mean, you say maybe he didn't, in fact, but a third party wouldn't know that.
Well, that again goes to the question of ostensible authority. But if we focus for the moment, just because I need to make this work, I need to get home on actual authority first of all. I mean, as far as actual authority is concerned, of course, it's right that under the terms of Clause 15, the insurance company is entitled to decide how to defend the action, and the Beacon case illustrates that you can even overrule the interests of, or overrule the wishes of the insured, and so we're settling this. I know you say you're not liable, but
Yeah.
I'm afraid we think you are, and since we're on the hook for the majority of this, we're going to admit liability and see what we can do by way of settlement. That's all uncontroversial. But of course, what's odd about this case is that the finding of the judge shows that actually there was no awareness on the part of the defendant at all that the proceedings had even been commenced. She was saying, or she subsequently said in the application to set aside, and it appears she'd said this on a motor accident report form of some sort, that actually she had a perfectly good defence to this claim. It wasn't her fault, it was somebody else.
Well, I think the accident report is in the bundle at, well, I don't know what it is at yours, but it's our bundle 561, the hard copy, and maybe it's 259 yours, but it's set out in an affidavit somewhere, and it's basically you're right, she's saying she had a defence.
Yes. There must be yet another set of numbers because I've got a medical report of 259. But anyway, I entirely take your Lordship's word for it. That's what it says. But yes, it says that she has a defence. And of course, the unusual fact, at any rate from a British perspective about this case, is that she is personally at risk.
Yeah. Because
there's no obligation to carry unlimited insurance, and she's got insurance which is limited. And this was it was immediately obvious. Must have been obvious. This was a very serious claim, very big claim, very serious injury. So she has. So my point about actual authority is she has clearly a very strong interest in how this matter is conducted.
I mean, this letter appears to have been written under the mistaken impression that the limit of liability for the insurance was the same as the limit of liability for compulsory insurance.
Yes.
I mean, that is the respect in which, let us suppose that the limit in the policy was also $1 million. This would not be such a surprising letter. What is surprising is that he should think that it was a matter solely between the insured and the victim, what happened to any sum over $1 million. So he obviously hadn't consulted the policy. But, I mean, so what?
Well, I'm not sure, my Lord, that it makes a difference whether he's right about the amount on the limit on the policy, because on any view of things, there was a risk that there would be a degree of uninsured loss that arose here. But my point is really that in relation to any third party who is considering what is going on here, who is actually defending this action, of course I accept in the ordinary course of things, if one isn't obliged to ask oneself constantly, is counsel for my opponent saying what he's just said with authority? Because by putting counsel into that position, the party has represented that counsel has got authority. That's plain. But on the facts here, it's clear from that letter, I say, that he's acting with the interests of the insured in mind exclusively.
But he must have been acting for the insured themselves, acting for the must have been acting for the insurer on behalf of the insured, because the statement "you're free to pursue any sum in excess of $1 million against the first defendant" assumes that a payment of $1 million would discharge the liability of the insured to that extent, which is necessarily means that he is saying, I am instructed by the insurers to settle $1 million worth of this claim with you on behalf of the insured. The mistake that he made was in thinking that that was in fact the limit of their liability when they had a contractual liability exceeding their statutory liability. And the statutory liability itself didn't arise at this stage because there hadn't yet been a judgment.
Well, my Lord, I of course see all that, but nevertheless, if the question is, looking at it from the perspective of the third party, of the claimant, on whose behalf is Mr. Gossin acting, then in my submission he himself makes clear that the answer is the insurance company in its own interests. My client, he calls them. He distinguishes between my client, the insurer, and the insured. So I would respectfully submit that any assumption that one could ordinarily make as a third party, that the attorney who goes on the record acting for the defendant is authorised by the defendant to do so, is entirely dispelled here. And of course at this stage, all that's happened is that he's put in an acknowledgement of service and a defence admitting liability. But the damage is really done when the court enters enters judgment. And if one thinks for a moment, what would have happened if the insurers had acted properly? As I respectfully submit, it was plainly quite improper of the insurers to do what they did. Because even if it might be said, well, the case was a very strong one and we have an interest in this up to $1 million by way of statutory liability and $1.5 million by way of liability under the policy, therefore we think we should admit liability. Even if all of that is true, they've got at least to speak to the insured, find out what she thinks. In circumstances where she's got, in fact, in pecuniary terms, a bigger interest in the matter than they have, as it turns out. But they don't consult her at all. They don't even tell her that proceedings have been issued. They simply go ahead and proceed with the whole thing with her remaining ignorant of it. And the reason that's important is because if they hadn't done that, even if, let's suppose that one can't quarrel with what's happened up to the stage when there's been an acknowledgement of service and then the defence has been filed, even if at that late stage they'd thought, well, perhaps we ought just to see what Mrs. Crossley says about all of this, and they'd gone to her, and she said, well, actually, I've got a jolly good defence to this case, because actually it was another car that bashed into me or came too close to me and I veered and it wasn't really my fault. There would have been an opportunity then to save the position, because they could have taken a view and said, well, all right, in the light of that, bearing in mind what Lord Justice Mance said in that case in England about the duty to act bona fide in the interests of insurer and insurers and insurer, we will seek to withdraw the admission of liability in the defence and give you an opportunity to defend on liability. But that's precluded, because all the way through they're acting entirely without consulting her. And that's why I say, as a matter of actual authority, they had none throughout. And if it's a sort of further if a further riposte to that is, well, yes, but they had ostensible authority, well, that's in my submission really negated by all the circumstances, in particular the terms of that letter.
Can we take this in stages? The claimants get the defence on the is it the 4th of January?
3rd, isn't it?
3rd or 4th.
It's dated the 3rd, but it's maybe the 4th.
And they get it from the lawyer who's gone on the record for the defendant, without at that stage anything to suggest that the lawyer is acting on a frolic of the insurers, if that's the right way to put it. A week later, they get the letter on the 12th of January. Now, do you say that letter, as it were, retrospectively, deprives the apparent admission of liability by the person on the record for the defendant of its force? I'm struggling to find the defence in my electronic bundle, but I'm assuming it just contains a fairly straightforward admission of liability and Mr. Gosin's signature.
The defence should be 281 in the hard copy, 281 in yours.
Okay, let's see if I can find it.
But he's already entered an appearance, hasn't he? 12th of November.
Absolutely.
Perfectly in order, again, denying liability. Not admitting it, anyway.
Well, now I've got it. I mean, it's the defence is straightforward admission of liability.
Yeah.
Immediately below a manuscript signature of Mr. Gosin.
Yes. Well, your Lordship's question was, does it retrospectively deprive the defence of ostensible authority? I mean, ostensible authority is about it being not permitted for somebody to deny the existence of authority
It could,
of somebody.
I mean, if it becomes apparent.
Well, it depends at what moment you ask the question and for what purposes. You can't go along in a situation where it's now become clear that there's no authority and say, well, it doesn't matter because there was a sort of settled authority at some earlier stage. It doesn't matter.
Well,
ostensible authority is a sort of estoppel.
The next relevant stage is when the court gives judgment on it, presumably on the admission.
Yes, that was I think the 16th of May. So I would submit that certainly by that stage it would not have been open to the claimant to say, well, you may not have actual authority, but you've got ostensible authority, because such ostensible authority as there might have been by virtue of the status of Mr. Gosin, and let's assume that he was entitled to go onto the record in the first place in the way that he did. Now, I need to come back to that point, because I don't want to be thought to be accepting that even that early stage is necessarily something done with authority. But let's assume that That was done with authority. By the time of the 16th of May, you've had the letter of the 12th of January, which makes clear who he regards as being his client.
Well, and
It's
that
the
he doesn't
insurance
regard himself as being in any way the lawyer for the defendant.
Well,
That's how you interpret that letter.
yes, it depends how you read the letter.
Assume that that letter of the 12th of January is effectively saying, I'm acting only for the insurer, I'm not to be taken as acting for the insured, then you say, well, what's been done previously must be read in the light of that.
Yes.
Certainly if no one's changed their position in the light of that, so that when you get to the judgment, you say any ostensible authority there might have been is gone.
Yes. My Lord, I said I didn't concede, not that it's for me to make concessions, but on this argument that even the early stages were done with authority, because it might be someone one can see, of course, that one might say, well, under Clause 15 there was an entitlement at least to deal with the litigation to the extent of doing things that didn't prejudice the insured, entering an appearance, and so on. But in fact, even in doing that, the insurance company were prejudicing, on the judge's findings, were prejudicing the position of the insured, because on the judge's findings, she'd never been served with these proceedings.
But no, that's,
So-
surely they're entitled. The argument against you on that is that it's not prejudice because she would have been served, and they're entitled to waive it. They can say, we're acting on her behalf, and we can waive it as she could have done.
If provided they act bona fide in what they honestly believe to be the joint interests of her and them.
Yes.
But there's no evidence that they were so acting.
Well, there's no evidence they weren't at that stage. I mean, it's really, up until the admission of liability, it all looks in order, doesn't it? I mean, I suppose you could say they might have informed her, but really, and perhaps they ought to be taking instructions a bit closer to the time.
Again, that comes back to the distinction between actual and ostensible authority. It all looks in order as a point about ostensible authority. As regards, but if what your Lordship means is did they had actual authority at that stage, I would say no, because the inference one can draw from Mr. Cossin's letter, and not just, I don't want to be thought to be hanging everything on that letter, but also from the simple fact that they didn't appear, that on the findings of the judge, they didn't tell the insured about the existence of the proceedings, or
well, on their own admissions, actually, on Mr. Cassin's own.
Yeah, that's quite, your Lordship, quite right. Yes. One might contemplate, I suppose, circumstances where one might say, well, that doesn't really matter because it's. But here, she's got a defence, and she's personally liable if she goes if she's vulnerable to this judgment. So I would say at all stages, up to and beginning with the entry of the appearance, including the filing of the defence and the submission to the judgment for damages to be assessed, nothing having been done in the meantime to try and row back from the position of the admission in the light of what the insured was saying about this accident, the insurance company was acting without actual authority. And essentially my short point is that that can't, in my submission, be cured by recourse to ostensible authority.
But if you're right about that, then anyone who conducts litigation on the basis of taking at face value what the other person's lawyer on the record is saying about the other person's position is vulnerable to some defect in the communications between the lawyer and that other person, and may find that the entire expenditure on the proceedings has been wasted when several years later the person in question comes back and says, well, actually, I didn't authorise him to take that step.
Yes, well,
Can litigation be...
I thought, you're saying, the whole point of the letter of the 12th of January, is that it's putting them on notice that this is a rather unusual position. You have to really found on
yes.
You say normal circumstances, yes, it can, of course, imply ostensible authority, but
yes.
Anyone reading that letter can see that Mr. Crossley is taking a very unusual line.
Yes.
That's where you have to put it.
Well, I think perhaps the answer to Lord Briggs's point is that there may be cases where actually that is the position. I mean, if there's a complete imposter just comes along and pretends to be acting for a particular party.
We're doing this on the assumption that there was a Clause 15 authority in the insurers to put Mr. Goseen on the record, and that means that he had the client's actual authority to go on the record.
Yes, I see that.
And I would gently suggest that in the ordinary run of cases, what the lawyer then does for the client can be taken by the person on the other side or the court as being within the lawyer's, it may be better to say apparent than ostensible authority, within the authority conferred by the retainer.
Yes. No, well, I can see that one. I don't think I can quarrel with that.
Your case really has to be, doesn't it, that sufficient notice that that wasn't the true position here was given by the letter. Yeah. Even though I assume that Mr. Goseen actively conducted the quantum.
He did.
He did, and in fairness to the insurers, he actively tried to get the quantum down in a way which made no difference to the insurers.
Right. So therefore, the impression being given to the other side and the court at that stage, on the basis of which expenditure was being incurred by the claimant in prosecuting the claim, was this was being done in the interests of the insured.
Well, yes, but by that point it was too late.
Okay.
Because at that point the parties were in discussion about what the extent of Mrs. Crossley's liability should be.
Completely extraordinary, as you said a moment ago, that he didn't liaise with her at all, as he says. As a matter of interest, perhaps, perhaps even comfort, what will be the consequences? Proceedings haven't apparently ever been brought against Tattle, but Tattle's prospects of recovering must be rather limited when they thought what they'd paid at any rate. But they couldn't be held liable for the additional 500,000 under the policy without fresh judgment. Presumably, I mean, on the present position, could there be fresh proceedings? Could there, or the proceedings have been set aside in their entirety?
Well, actually,
and it's too late for fresh proceedings.
Well, what was sought, I'm not sure we've got a copy of the order that was actually made by the judge. What was sought in the application was not the setting aside of the entire proceedings, but the setting aside of the judgment for damages to be assessed, and an order for liberty for the defendant to enter a defence and contest proceedings on the merits.
Oh, I see.
So the action before the order for assessment of damages is still live?
On what's been sought, I think that's right. And whether that was a wise thing to have sought on the defendant's behalf rather than actually seeking to have the whole proceedings chucked out might be a matter in question. Certainly now, speaking in 2018, when there's a 4-year limitation period in Trinidad and Tobago for actions in tort, it might seem that it would have been better to seek the whole thing to be chucked out, as it were, speaking in rather general terms. But as I say, that's what...
It was a tactical decision not to go that far, because it might have been... I suppose it wouldn't have been time-barred at the time, no.
But if one's going to say that that there was no effective entry of appearance, this is an all-or-nothing thing. You can't say the appearance is effective as regards part of the claim, but not as regards the other part.
Yes, I can see the force in that, my Lord.
Yes. You wouldn't set aside the proceedings, though. You would set aside the appearance, wouldn't you, in the defence? So,
well, the proceedings would have to be set aside if they were not if there was no appearance.
No, the writ would stand. You wouldn't be
well, the writ would have expired.
Yes, it would have expired. No, I think on reflection, I think Lord Sumption must with respect be right, that whatever exactly it was that the defendant had applied for, it may be that there's an order in here, and I've overlooked it. I don't know whether my friends can assist with that and see what in fact was ordered by the judge at first instance. But certainly logically on his findings, he ought to have set aside the entry of appearance as well, and that would have had the effect that the claim form had expired.
Well, I find that would be a monstrous result, wouldn't it? Isn't there some way in which the law or the procedural rules could achieve the result that everything on the defence side was set aside, but the claimant, who wouldn't know anything about it, could nonetheless continue with her claim. And I suppose it would be her fault for not serving it properly, is the reasoning.
Yes, I mean, the court's got a jurisdiction, of course, to extend the validity of a writ, of a claim form, but query whether it could do so on the basis that, on the basis of these facts, because, as your Lordship says, it was entirely the claimant's fault.
Right.
So, my Lord, really those seem to us to be the points that one might make in the respondent's favour concerning clause 15. I haven't touched much on the proposition of law, which I noticed your Lordship, in the course of my friend's submissions, said rested to some extent on a few words in a judgment in the Taiping case. Now, one recognises that your Lordship wasn't confronted with the question that arises in the present case, so it would be unfair to read too much into them. But as a matter of general proposition, in my submission, it must be right that the ordinary law of agency applies, so that if a person is clothed with authority in principle to do certain things, but does them entirely
back to being a question of actual and apparent authority?
Yes.
He has the authority vis-à-vis the third party, even if he's exercised it in a way that makes him liable to...
I mean, if you know he hasn't got the authority, then you're in trouble. The thing's a nullity.
That's back to... Yes. Well, again, one needs perhaps to keep the two pretty firmly compartmentalised. There's the statement I think we've put in the note from Bousted on agency, which quotes an old case. It's the bottom of page 6 of my note, para 32. Every authority, and over the top of page 7, every authority conferred upon an agent, whether express or implied, must be taken to be subject to a condition that the authority is to be exercised honestly and on behalf of the principal. That is a condition precedent to the right of exercising it, and if that condition is not fulfilled, then there is no authority. And any act purporting to be done under it, unless in dealing with innocent parties, is void. And as I say in the parenthesis, the qualification is not a qualification on the scope of actual authority. It's about ostensible or apparent authority.
Yeah.
Well, and then subject to notice by the third party.
Yes, well,
that's why they're
notice by the third party implies, I suppose, that there needs to be something done to displace what is, on the face of it, apparent authority.
Apparent authority depends on what's apparent to them.
Yes.
So unless it was apparent to them that there was no actual authority, they're entitled to rely on what's being said. In the context of litigation, the clarity of these demarcation lines is absolutely critical. The whole system depends on it.
Isn't that what's meant by innocent? Yeah.
Yes, that's short. I think. Bousted says, and we say they're right, that unless indeed with innocent parties is shorthand for that. But I mean, bearing in mind that the burden of proof does lie on the person asserting that the principal is liable because of what the alleged agent has done. It may be said to be a bit not quite right to put it on in terms of notice. It's a question of whether it's simply a question of whether there is apparent authority, which can be traced. The representation that the agent has authority has to be traced back in some way to the principal. But I take your Lordship's point in the context of litigation, of course, where if there's once authority to appoint somebody to act, then questions of notice might arise, because you might say, well, so long as nothing's been said to displace the ordinary presumption that a properly appointed person
I mean, it's not just a
has authority, then they have authority ostensibly.
So to speak, on a balance of probabilities, it's a presumption which is absolutely fundamental.
Yes, but it's a factual presumption.
I mean, people don't even ask themselves, is what counsel is telling me authorised? The whole system depends on the proposition that you can take that for granted without further inquiry from the mere fact that he's on the record, provided he's on the record with actual authority, but that's all water under the bridge by the time these questions arise.
Right.
Yes.
How much...
Well, I think I'm more or less there. It's probably unnecessary to say so, but I've set out in the note why we say the insurance cases support the analysis that I advance in relation to the question of actual authority. It's true that there doesn't appear to be a case that actually says in the insurance context that there is no authority under a claims control clause unless it's being operated properly. The cases are all in fact about, well, there aren't many cases, but both, I think, Beacon and Groom and Crocker itself were in a slightly different situation where the question was, has the insurer acted properly or not? So it was a question of whether it was a breach of contract.
Well, but,
it goes to the...
Groom and Crocker proceeds on the basis, doesn't it, that after service, the solicitors had apparent authority to do what they did. But then it was monstrous, and the claim against the solicitors by the insurer succeeded. So, I mean,
that may be... That might
been saying.
They don't go into that issue. That might well be right, but they don't go into it because it wasn't being said. It wasn't being said by a third party. You didn't have authority, or rather, it wasn't being said by the insured. You didn't have authority to do this. Therefore, as against you, the claimant, I'm not liable. What was being said is, you've made me liable, and you, insurer, have made me liable, and I want damages.
They accept what I think
Yes.
we've arrived at as more or less common ground, but
Yes.
in the ordinary course there would be apparent authority.
Yes. Well, I think I can take everything else extremely shortly. The points on the facts, I don't have any particular submissions to make about the appeal on the facts. It's true that one can point to certain aspects of the judge's findings which raise an eyebrow, but that's often the case, and it's not, in my submission, a case where one can...
It would dignify what happened in the procedural appeal to describe it as a concurrent finding on the facts, wouldn't it?
I can see why Your Lordship says that.
I mean, the facts were in fact dealt with in the submissions, but I didn't see any argument about them at all.
But one
that's
can see
true.
why a court confronted with this might well say, well, look, these are findings of fact made in a witness action. The circumstances in which the Court of Appeal would trawl through the transcripts and say, well, the judge got it wrong, especially in a classic, you said this, no, I didn't kind of dispute, must be pretty rare.
Yes, but,
yes. I mean, I suppose there is this point to be made in answer to Your Lordship's point about the Court of Appeal. It's true that the oral submissions didn't trespass upon the question of the facts at all.
No.
On the other hand, it's also true that the claimant wasn't exactly represented by a shrinking violet of counsel. I mean, he put up a pretty good fight against the Court of Appeal's attempts to tell him that he was talking nonsense about Groom and Crocker. So one assumes that if they really, at that stage, if the claimant at that point really wanted to pursue the appeal on the facts, then it would have been done. One rather gets the impression that by the time it got to the Court of Appeal, it was certainly in oral argument.
One wonders whether the first Court of Appeal didn't discourage the appeal on the facts.
Well, maybe. But I agree with the Lordship about concurrent findings of fact, but it's always occurred to me it's a rather odd expression anyway, because the Court of Appeal by nature doesn't find facts. It reviews the lower court's findings of fact. So it's really a shorthand way of saying where you've failed on the facts first time round and you haven't managed to displace those facts in the Court of Appeal, we won't get involved unless there's something pretty egregious.
And the reasoning behind it is that the Privy Council is not in a good position to question the judge's findings of primary fact if the Court of Appeal hasn't done so.
No.
Yeah.
But has the judge taken advantage of the requirement to step back and look at the overall probabilities in this case? I mean, where did these documents fall from?
Well, no one has sought to answer that question, and I'm not sure that I can offer anything other than speculation on that question.
What was the process server doing unless he was serving process?
Well, those are all points which no doubt were advanced to the judge, but he had the advantage of actually seeing everybody and found that they were
I found a
unconvincing.
particular lack of answers to those questions in the responsive submissions, which were commendably and perhaps strategically brief. Anyway, there we are.
I take your Lordship's point entirely. I think the only other point, my Lord, was the point about jurisdiction, but I hope that I've dealt with that by reference to the Nelson Authority. And it must be right in my submission that if it's right that you've in fact been brought into proceedings as a complete stranger, then the court can do something about it. It's a different case from a case where there's been a judgment on the merits in a properly constituted
Well, that's a very fair point, Mr. Rowe, and Anything more?
Not from me.
No, I think we're all indebted to you for appearing here pro bono. Right, let us go back then to Mr. Zen.
Thank you, my Lord. My Lord, just one point briefly in concerning the letter of the 12th of January, which Learned Senior had referred to, the one written by Mr. Gosain to Tatil. My Lord, we are humbly submitting that there's nothing sinister about the letter. While it may not have been drafted in terms suitable, but when one looks at I don't have a copy of the judgment, but it is a judgment of this board, Presidential Insurance Company versus Molly Hussein Stafford, 1999, UKPC 14, paragraph 8, please, my Lord. It says, if I may just be permitted,
Sorry, it's Presidential
Insurance Company.
Is it in our bundles?
No, please, my Lord. I'm just using it to
Right.
Yes.
just address what
UKPC 14,
Right.
paragraph
14,
18. Did you-
paragraph 8.
8.
Eight,
Yes.
Eight, yes.
sorry.
Yes, okay.
Yes, and just this
Which year are we looking at?
1999.
1999. The scheme of the statute is the same as that adopted by most other Caribbean countries. It requires drivers who have compulsory third-party insurance to cover in respect of any liability which may be incurred by him or them in respect of the death of or bodily injury to or damage to the property of any person caused by or arising out of the use of a motor vehicle on a public road, section 4.1. This obligation was, however, qualified by subsection 2, which provided that the policy is not required to cover, among other things, liability in respect of any sum in excess of $50,000 arising out of any one claim by any one person. The provision upon which Mrs. Stafford sued was in section 10 of the Act. This section gives a direct right of action by the injured person against the insurance company. The right is defined in terms which refer back to the cover required by section 4. So really, in essence, all Mr. Gosain was doing was in line with my Lord's judgment, just identifying what the statutory limit was to the appellant's attorneys at that time. So,
Yes. Well, he, what? Mm-hmm.
Yeah.
Yeah.
that is all I had to just say on that point.
Well, we're grateful.
Thank you, my Lords, for the opportunity.
Well, the board repeats its gratitude to Mr. Rowe and indeed to both counsel for their helpful submissions, and will take time to consider its judgments, which will be handed down in the usual way.
Thank you kindly, Mr. Mayor.
Thank you very much.